My name is Martyn Redstone. I am the head of responsible AI. So today we are looking at an important development in how artificial intelligence is regulated within the employment sector. And we're going to be examining the recent amendments to Illinois' Human Rights Act, specifically House Bill 3773. Our focus today hopefully is going to be quite practical. So over the next 20 minutes or so, we're going to outline what Illinois regulation now requires for organizations using machine-based systems in employment and how accountability is structured under those new rules. So we're going to move beyond some of the high-level summaries and we're going to look to the specific differences between generative and predictive AI under this statute. We'll walk through exactly what a technical proxy audit looks like in practice, examine things on programmatic radius targeting, and discuss the operational realities of non-compliance. And the goal is to provide you with a clear operational framework so that you can constructively manage risk and ensure that your technology stack remains compliant and remains defensible. So let's begin by establishing the baseline requirements. So here's the core takeaway for your executive and operational teams. Effective beginning of this year, January the 1st, 2026, HB 3773 amends the Illinois Human Rights Act to require employers to provide formal notification whenever they use AI to influence employment decisions. Importantly, the amendment explicitly prohibits discrimination driven by AI, which in this case directly addresses the use of zip codes as proxies for protected classes. Now, I want to pause on the timelines. While 2026 may seem like, by the end of 2026, might seem like a future milestone, in the context of enterprise HR technology, it's an immediate operational consideration. We start considering standard procurement and deployment cycles. So if your organization is now selecting a new HR technology vendor, programmatic advertising, talent CRM, ATS, that system will be operational by the end of the year. And if you do not baseline their compliance with these regulations during that RFP process now, you risk inheriting some technical debt that will be very difficult to untangle when the deadline hits at the end of the year. So Illinois is establishing a more structured standard for compliance, relying on generalized vendor assurances or treating AI as an opaque process will no longer meet regulatory expectations. So let's examine how this shifts the compliance landscape. So why is this specific regulation noteworthy? Primarily because it clarifies how liability is measured and addressed. First, we're seeing a meaningful shift towards outcome-based accountability. Employers are liable if their AI deployment results in a discriminatory effect on protected classes. Not your vendors, employers are liable. So notice the focus on effect as well. The regulatory standard prioritizes the outcome of a system rather than the intent behind it. I thought it wasn't biased. I expected it to be unbiased. It's the output, not the intent. And an organization can have perfectly neutral intentions, but if the algorithm produces a skewed result, liability applies. And second, compliance missteps are now formalized. Failure to provide the required notices or the use of prohibited technical proxies constitutes, in this case, a civil rights violation, a violation even. So let's look at the practical implications of non-compliance under the framework established by the Illinois Department of Human Rights. So if the department is notified of a violation, for example, a failure to provide proper AI notice on a job application, they can launch a preliminary investigation. And if a violation is found, they issue a notice to show cause. This grants an employer a 30-day window to correct that violation. And if it isn't corrected, the department may initiate a formal charge of civil rights violation. Cost here, not just potential regulatory fines, but the significant legal expense of defending against a disparate impact claim, combined with, obviously, the reputational risk of a public inquiry. So the third point here, the functional scope is comprehensive. The legislation extends beyond initial resume screening or hiring. Regulatory oversight now includes hire to fire, promotion, renewal, discipline, firing, discharge, redundancy, selection for training. So if a machine-based system influences any of these life cycle events, it falls within the scope of this. And finally, HB 3773 reinforces the need for shared responsibility with vendors, as I said earlier. So while third-party HR tech platforms build the tools, the regulatory expectation places the burden of oversight on the deployer, the person putting these tools into the market, the employer. So proactive due diligence is really essential because the deploying organization is ultimately accountable for the outcomes generated. So to maintain a defensible posture, the statute outlines 5 core operational requirements. Number 1, mandatory AI notifications. Employers must notify applicants, candidates, and employees that AI is being used to influence or facilitate covered decisions. And it's important to understand exactly what that state considers AI. Interestingly, HB 3773 provides precise definitions, and it explicitly covers both predictive and generative AI, or as some people in the industry call it, old AI, new AI. Predictive AI includes those traditional kind of machine learning models, score assessments, or rank resumes based on historical data. And generative AI, kind of post-chat GPT world, includes automated systems that simulate human-produced content. So, for example, if you use an LLM to automatically summarize a candidate's interview transcript and generate a recommendation paragraph at the end of it for a hiring manager, that generative output is facilitating an employment decision. It's fully covered by this law. Number 2, technical proxy prohibition. Sorry, it's the end of the day for me over here in the UK. My teeth are falling out. Systems cannot use zip codes as a proxy for protected classes. And I'll explain what this means in detail shortly. Number 3, accommodation transparency. Notices must do more than fulfill a legal checklist. They need to inform individuals of their right to request a reasonable accommodation. So let's walk through what that means in practice. So imagine a candidate encounters an AI-driven video interview platform. A compliance system does not bury the notice in a privacy policy. It provides a clear front-end disclosure before the process begins. So this disclosure must include a direct mechanism, such as an email address or a dedicated link to request an alternative process. So the organization, your organization, must have a defined operational response. So if a candidate with a neurodivergent condition requests an accommodation because the AI analyzes eye contact, your recruitment team must be prepared to seamlessly transition them to a human-led interview without pausing or disadvantage their candidacy. And I heard a great example of this earlier. What happens if all the technology turns off? That's what you've got to think about. That's the process to put people through. Number 4, rulemaking compliance. Organizations must adhere to the rules set by the Department for Human Rights in Illinois regarding the time, means, and conditions for providing that notice. And number 5, record preservation. All AI-related notices and disclosures must be maintained for a period of 4 years. So establishing that audit trail is a foundational part of demonstrating long-term compliance. So let's clarify who is covered by these requirements. The scope includes several key entities. Direct accountability applies to employers. Anyone with one or more employee in Illinois for 20 weeks of the year. It also applies directly to employment agencies, staffing businesses, which includes RPO firms as well, staffing agencies, and platforms that recruit or refer employees as well. To illustrate how this shared liability works, consider a recent scenario involving a mid-sized RPO, recruitment process outsourcing. So the RPO utilized a machine learning tool to source and curate shortlists for an enterprise client. And the tool optimized for candidates who had historically high retention in a specific industry. And however, the model inadvertently filtered out candidates from certain educational backgrounds that highly correlated with age and national origin. Now, under Illinois law, both parties face exposure. The RPO, acting as an employment agency, is accountable for using a system that generates discriminatory referrals. Meanwhile, the end client, the employer, remains liable for the discriminatory effect of the hiring decisions made based on those shortlists. You cannot use contracts as a way to get around civil rights obligations. Labour organisations are also covered alongside public contractors as well. Now, crucially, AI technology vendors must also adapt. So while the employer holds the primary liability, vendors need to provide the necessary technical documentation and bias monitoring data. So if a vendor cannot validate their compliance with the proxy rules, it creates a significant gap in your organization's defensibility. So when the regulation addresses discriminatory effect, it requires systems to remain neutral across all categories protected by the Illinois Human Rights Act. Now, this includes race, color, ancestry, including traits associated with race, such as protective hairstyles, religion and national origin, sex, which comprehensively includes pregnancy, childbirth, and related medical conditions, age, specifically protecting people over 40 and over, both physical and mental disabilities, sexual orientation, gender identity categories, and specific classes such as military status, marital status, arrest and conviction records, and citizenship status. Ensuring AI systems do not generate disparate impact against these groups requires structured oversight. It's not enough to test for gender and race in isolation. Algorithms are very complex, and bias often occurs at the intersection of characteristics. For example, older women or veterans with disabilities. Robust auditing requires multivariate testing across this full spectrum. So this brings us to a specific and important mandate within HB 3773, the prohibition of zip codes in AI models to prevent proxy discrimination. So while a zip code is geographically neutral, in algorithmic modeling, it can inadvertently function as a stand-in or proxy for protected classes. Proxy discrimination occurs when a non-protected variable correlates so highly with a protected characteristic that relying on it produces a biased outcome. So let's look at practical examples involving programmatic job advertising. A company seeking warehouse workers utilized a programmatic advertising platform. The vendor suggested using a commute radius filter, targeting only candidates who live within 15-mile driving distance of the facility, arguing that, quite rightly, shorter commutes improve employee retention. And the AI platform anchored this radius using zip codes. However, the facility was located in a predominantly white, affluent suburb, And by drawing that strict kind of 15-mile radius, the algorithm systematically excluded applicants from several urban zip codes that were just outside of the boundary, which had a significantly higher minority population. The intent, commute optimization. The effect, racial filtering. Now, under HB 3773, that outcome is a civil rights violation and the employer is accountable. So how do you prevent this? This is where technical proxy audit becomes essential. You must require your vendors to demonstrate how they audit their models. A thorough proxy audit generally involves 3 steps. First, feature inventory. The vendor must map every single data point that AI uses to make a decision. Second, correlation testing. The data points like location, universities attended, graduation years are tested against demographic baselines to see if they highly correlate with protected classes. And then the algorithm. If a correlation is found, the vendor removes that specific feature, like I said, like the zip code anchor, and reruns the model to ensure the predictive validity remains without the disparate impact. So if a vendor like a recruitment marketing vendor currently relies on radius targeting, you must initiate these conversations to ensure that their logic is not inadvertently creating a discriminatory effect. Looking at the timeline for implementation, the effective date was January the 1st this year, January the 1st, 2026. And that's the point at which AI notices, proxy prohibition requirements become enforceable. But Illinois is part of a broader jurisdictional trend, and they're joining places like New York, where they already have local law 144 requiring bias audits, Colorado, which recently passed quite a comprehensive AI Act covering high-risk systems. We're moving from a period of self-regulation into an era of formal statutory oversight for employment technology. Now, currently, with Illinois, we're in that rulemaking phase. The department is drafting specific guidelines, which will outline things like notice templates, accessibility standards. And we recommend monitoring these updates quite closely as they'll provide that precise operational detail required for your compliance. The regulation is live from January the 1st this year. We don't have a grace period. This is now live and you need to make sure that you are compliant ASAP if you aren't already. So to prepare for compliance, here is what you can do from a takeaway and action perspective. So the first one is perform a system inventory, map out exactly where machine-based systems are currently used to facilitate decisions across your employee lifecycle. This includes ATS screening, CRM matching, programmatic ads, video interviewing, the full kit and caboodle. Number 2, conduct a technical proxy audit, have collaborative, documented discussions with your vendors. Ask them specifically, how do you ensure geographic data or other variables are not functioning as proxies for protected classes? Request their technical validation documentation. Step 3, you need to deploy those standardized notices. Ensure that AI usage notices are integrated into your standard workflows. They should be provided to current employees, updated when systems change, and prominently included in job postings as well. Step 4, institutionalize reasonable accommodations. You need to update your process so that AI notices also include that clear point of contact that I mentioned earlier and a straightforward method for individuals to request alternative screening methods. And step 5, conduct a disparate impact assessment or test. So while the statute forces on prohibiting those discriminatory effects, proactive independent bias audits are absolutely the most reliable way to monitor your system over time and demonstrate responsible governance. And we'll be sharing with you in the follow-up email a new audit solution that we have that covers HB 3773 as well. So as AI regulations mature, defensibility relies on clear oversight and structured governance. Illinois is providing a strong outcome-focused framework on what accountability looks like moving forward. And to support organizations in meeting those exact technical thresholds, like I said, Warden is currently developing a dedicated HB 3773 audit package. I'm not going to dive into the technical specifics right now of it, but we'll be sharing more details on how this package maps into the Illinois mandates in the follow-up email you'll be receiving after this briefing. I also encourage you to download our full Illinois HB 3773 regulation guide, which we'll link to again in the follow-up email, and subscribe to Warden's updates on all things regulation. We'll also encourage you to seek independent legal advice if you need it. Warden is not a legal advice provider, and everything we say here is our interpretation of the regulations. But if you do have any specific questions, please feel free to reach out to me. My email address is on the screen there, martyn@warden-ai.com. And again, you'll get those details in the follow-up email. Now, we have about 5 minutes left of the time that we provided for this. So if anybody does have any specific questions, you have 5 minutes to ask them, and we'll be staying online for those 5 minutes. If you don't, then I look forward to seeing you at our next regulatory briefing coming soon. Do feel free to use the chat feature if you do have any questions. Ensure that you are making sure that you're sending that message to everyone or just to me. Happy to look at those individually as well. Okay, I'm getting a couple of thank yous in the messages, which is very kind of you. Hope you found this very useful. Seeing as there are no questions coming through, we're going to cut the session short, giving you 3 to 4 minutes back in your day. I hope you take advantage of them. But thank you so much for joining Warden on this regulatory briefing. And we'll be sending the follow-up in due course and look forward to seeing you at the next one. Take care. Have a great day wherever you are.